From India, and I work in the taxation and the tax dispute and advisory. We provide support to our clients in international taxation, principally transfer pricing issues and double taxation avoidance agreements. And in the past, we have done some reasonably significant work with respect to various countries, those who are having the executed double taxation avoidance agreement with India. And we also do the indirect taxation, and which is known as goods and service tax. And the new age technology has brought forward several new challenges before the enforcement authorities, and how to enforce and how to create a balance in the recovery of taxes and the maintaining the balance between the business and also between the government. So now, why this topic is maybe of some interest to the international community, though it is very much localized and it pertains to India, but because today's global world, the investments are made by different countries and through different entities within the country. Now, all the countries are having, one way or the other, some kind of arrangement, maybe in terms of investment treaties or some other additional agreements between the India and that of the countries. So now, the market statistics, which is important as a market information, is about why it is such a big industry, and because the sheer population of the country, and almost around 32% of the Indian population is into the gaming exercise, and the 32% of 14 billion population is a huge number, which is also growing at the rate of 16.5% CAGR, and 16.5% CAGR, that means a very robust situation or robust business situation 5 years down the line. Now, what has come forward all of a sudden that it has triggered the debate between the legal circle is that the new law was implemented in 2017, and 2023 the entire law has been changed. Those who have set up the business, they are at loss, and they are shockingly surprised also that what to do and how to do, whether their value has been completely eroded and whether they should wind up and what should they do. So now let's see that what, as especially in a country like India, what are the devices the government has adopted. So there is a situation where 2017 to 2023, October 2023, because the new law has come in July 2017, and the 2017 they revamped the entire law of the country, where the federal structure was created, and all the 28 states plus 8 UTs have come together along with the Dominion, the central government, to come out with the creation of a new law. So initially, that there were this illustration which I am presenting to you is about the Gamescraft litigation, which is the largest litigation right now in the country, and where they have created a liability almost about 25 billion. That is too much a liability for any business to sustain, and that too from a retrospective dates. So in a tax situation, there are 2-3 very important aspects. One is the rate of tax, which either kills or gives the benefit, or the value of taxable supply. That is another very important aspect. And the third is the taxable event. So there was a situation in the Gamescraft matter where the game of skill, because it is about rummy game as a game of cards, that is taken as a game of skill by several judgments of the Supreme Court of India, and where consciously all the states and the central government had decided that they will only impose 18% of the tax. Now, there's a game of chance which falls into the realm of gambling, though it is prohibited, and nobody is allowed to play those games except few northeast states, which has permitted by special license. So that was a debate, and that continued. The situation was all right from 2017 to October 2023. And I have given some illustration also that how the fees was levied, how the tax was imposed. The tax was imposed in those situations is only on the platform fee, not the stakes placed by the players. Now, subsequently, that Department of Taxes has initiated an investigation action, and that investigation action was aimed to create all the game of skills to a game of chance. And the purpose was to collect maximum revenue. And that's how the entire matter proceeded. So there was a debate from the competing arguments that whether the rummy is a game of skill or game of chance, whether the game of skill or the skill itself controls the chance, and which will have the dominant element. So the dominant element, as the court decided, is the skill, and the skill can control the outcome or the success of the player. So that's how they decided. So that decision came in May 2023, and it was a very elaborate decision, 325 pages, by Karnataka High Court, which is at Bangalore in India. And subsequently, what happens, what is the reaction from the government? And it is important, why it is important that everyone who has made the investment in the country and has seen such a situation where they could defend themselves successfully in the court, what they should do next. Now, the situation has reached the Supreme Court of India, but the government reaction came in the form of a Validation Act. That Validation Act in the past has also triggered international disputes also. For example, Vodafone is a classic example of it. Where Vodafone was imposed a retrospective tax, and it was a large amount, and which actually forced the Vodafone to offload its equity to another equity partner, which is Idea. Now, this situation, while they have successfully, they secured the success before the Supreme Court of India, because of the share transfer was taken as a capital gain. There was a question that whether the capital gain should be applicable on the transfer of shares or not, and whether transfer of share or the share itself qualify to be an asset. In that case, they succeeded in the court, but the government brought the Validation Act, government brought the retrospective amendment, and that led to complete exhaustion of all kind of remedies available in the host country. Now, that led to the international arbitration under the bilateral investment treaty between India and Netherlands. And subsequently, on FET standards, award was given in favor of Vodafone, and that is a similar situation which is arising today. And now, what has happened here, that in the amendment of 2023, that the online gaming, which is a game of a skill, has been defined to be gambling. It is a similar situation what has happened in June 2020, when the TikTok and several other apps of the China, they were banned. And that also triggered the debate whether there should be arbitration, whether there should be international dispute resolution under ICDS. And despite the fact that 2018, India, China both have terminated this agreement in 2018. But because of sunset clause, the debate is still on whether there should be international arbitration or international investment state dispute settlement mechanism or not. So the similar situation has arisen where the game of chance or skill has been made a game of chance and become gambling. So this is a regulatory exercise. In a regulatory exercise, the activity has become prohibited, or in a way restricted, severely restricted. Number two, they have used the legislative device to impose the higher rate of tax, which is from 18% to 28%. Instead of platform fee, they have taken the entire stakes placed by the players as taxable value. So the ultimate burden has gone beyond 80%. So there are two things which has happened here. One is that the regulatory prohibition which has come, which will actually invoke any government regulatory authorities to go after them to stop the business. Number two situation, the 80% tax burden, which is going to create a severe financial crisis for any company to survive. And that too, the amendment has come from a retrospective date, which is 1st July 2017, though it was made ostensibly applicable from 1st October 2023. So in that situation, the question comes where the investor should go. So now the matter is before Supreme Court. Supreme Court is going to decide, but the Supreme Court is facing the challenge whether they can revoke or they can question the legislative competence of the Parliament to legislate in this particular manner. The answer is, in most likely situation, as my Indian lawyer colleagues know it, that the companies are going to lose because Parliament has the power to even tax the oxygen and the breathing activity as well. So now, given that hostile environment, unsustainable situation for the firms to leave the sector because there is accounting as well as economic loss, both the losses. The books will also show the loss, and also actually all the implements of the production cannot be paid up. And the third economic situation which arises for them is that it is not the case where the more consumer actually result into reduction of the cost of providing the service. That is a very unique situation in this case. Otherwise, over a period of time, the delta customer has a very nominal cost of providing the service. So now, what is the way forward? That is only a debate, and that is only a question, and there is no solution. There is only a matter of proposition which can be considered by the legal community. It could be a situation where the investment treaty could be between different countries. It could be Netherlands, it could be Cyprus, it could be UK, it could be China, it could be any other country, from wherever the investment is routed into that platform. So what qualifies somebody to go into that arena and invoke that remedy to claim the compensation? So now let's take example. I have taken example from India-Netherlands, a bilateral investment treaty, and which is almost same because it is based on the UN model, and all the countries have adopted that. So now the platform question comes whether the platform can qualify to be an asset and therefore to qualify as an investment. Only then it can fall under the category of this particular treaty. So now this is generally known as Article 5, and Article 5 has Roman 3 and Roman 4, where it says the commercial contracts. In a situation like this, the commercial contracts are always executed which has some monetary value on some commercial aspect. That will fall under, in my understanding, it will fall under Roman 3, and in Roman 4, like platform, source code, and the domain name, and all other related intellectual property will also fall under the category of Roman 4 and Roman 3. So if this qualifies to be investment, then it is one of the assets, or which includes every kind of assets invested, will qualify to be invested. Now the question is, in order to trigger the compensation claim, then whether there should be direct or indirect expropriation. And it can qualify to be so. In that case, it has to be either direct expropriation or some measure which is having the effect of expropriation. And what could be that? It could be in the form of where the economic value of the business has diminished substantially. So once this kind of step is taken, when the prohibition is created in order to reduce the economic value of the business, probably this could be indirect expropriation. And if that be the so, probably it will also fall under the category of FET standards. So this is the debate, probably which which is for the legal circle to take it further. In a hostile situation like this, where the legislative device is used for the purpose of stopping the business and for the ostensible aim of collecting more revenue, then what should be done? So this is the very, very brief and concise case study which is relating to the Gamescraft case, and the way forward from there is the issue. And in the past also, that Vodafone is the only one example which has come out from the India-Netherlands investment treaty, and otherwise there is no other example as far as my knowledge goes, so far as India. So this is the brief summary of the case study which I have done, and to brought it to you for your for your thinking and for your consideration. And in case any because there's no solution, but we can always discuss it in case anybody has any question. I think if we don't have any question, probably we can, any other aspect which anybody wants me to deal with out of the presentation, because it's very domestically localized issue, but it has international ramifications. So that's how I'm here.
So do we have any question from the audience?
Okay, thank you so much. Thank you so
maybe
much for your time.
you can catch him during the break.